what will be the implementation of a law and how it should not be. Constitution, basic document. Like, I don't need to say this. Contract law, basic document. CPC, if you want to do litigation, whether in firm or whether in an independent practice, CPC, fundamental document. Evidence Act, fundamental. If you want to do commercial sort of litigation or practice, Companies Act, of course. In college, I'm talking about all these subjects in college. You should pay as much as focus on all these subjects. Property Act, Rights to Property Act, then Specific Relief Act. People don't put any attention to Specific Relief Act. It's such an important, legislation. Evidence Act, of course, I said CRPC, So these are the basic subjects which you should read. I will always advise to read and see now with the advent of technology and, a lot of data is available just on Google. You don't have to subscribe to any sort of Manupatra, nothing. Of course, we have a very beautiful library. There are a lot of books. If you're interested, you can go to a library for the purposes of reading or otherwise. What I'm suggesting that read judgments. And that is all what I'm going to say. Read as much as you can judgments. And follow up. Like, there will be judgments which has subsequently will overrule or whatever. Do an authority check. When you're reading a judgment, always do an authority check. That is what we tell interns when they come up with a research to us. The first question I ask is, have you done an authority check? Because sometimes they come with a judgment which is overruled, distinguished, or something has happened. So reach to a final conclusion and always have a solution-oriented mind. When a client comes to us, of course he knows he's in trouble, right? Something has gone wrong. So even as a student, when you're reading something, have a solution-oriented approach. How you read something to provide a solution to your client, how you will get out of a situation, not to twist the law. I'm not talking about that. I'm talking about, of course, if your situation, if your client has done some violation, of course you will have to tell him and you will have to face the repercussion. What I'm trying to say, that your approach should be, when you come to the field, not purely academic, because it will create problems. Your approach has to be solution oriented. And in college, read. When I say read, I just explained, so I will not reiterate on that.
Okay, for independent practice, before I come to the skills that you should work on, I think there is certain, again, temperament that litigation requires, and probably you should check whether you have that to go for an independent practice. One is it is physically taxing. It is physically taxing to run from court to court. You have to carry files initially. Climate, say Delhi climate is harsh. And it's a practical problem, black coats, black gowns. It is so hot. Secondly, you should have a temperament of meeting people. You should have that thing because you need to generate clients. When you are independent lawyer, the primary focus is where does your work come from? And work comes from over the years. You have to constantly build your circle and constantly work upon it. It's not that today, after 13 years, I can say that I can just sit back. I've made my circle. It's not that. Wherever, whatever, meet people, understand, and also because we take up anything, because when whatever work will come to you initially, you will not say no, whether criminal, whether property, anything, you don't want to say no. Now, how do you approach that work? For that, you need people to know people in different fields. For example, if there's something medical, not just a lawyer, maybe you want to go to a doctor and ask that how does it work. I had a matter on structural stability of a building. I had approached an architect to understand. I could approach because I had such friends. And again, it's building on those relationships and maintaining those relationships for years. Also, you need to be thick-skinned because judges at times are harsh. They will probably blow you in the court, and it should not matter to you. You should have the ability to blow it off. Now, what are the skills? Certain skills, basic, that you need to have, and certain you probably need to inculcate. I feel that there is one skill that an arguing counsel must have, is about structuring, a mental structuring of what you're talking about. You should map it in your mind that this is how I'll approach this. Also, marking a point. you would have come across people, just a normal talk you're having, and they probably go on in a different tangent. You're talking about something, they go on a different tangent. Do you have the ability to bring it back to the main point? And that's what I call marking a point. Because many a times, what happens in court is you decide these are my 6 points in this list of priority. You start with point number 1, and court say just come to point number 5. You should have that marking in your mind that 1 is my strongest point. I have to somehow bring him to that. You cannot have that thing that you, with the judge, you also forgot what your point number 1 was. So that is a skill. Basics, you should at least have that skill, and you work on it, you learn it, you see your seniors arguing, you understand that skill. Again, reading habit, very important, because everything is there. Any issue that you come with, you will probably find arguments from both the sides. It's just that you need to it is your interpretation. It is there in the judgments. You and of course authority check what the cast says. Absolutely. A lot of times also new associates or interns come, they Google it up, and it's interpretation of some judgment they bring. That from a law school you cannot do that. You have to read that main judgment, or probably have that main notification of the government, and then depend on it. And an interpretation does not work. Again, I'll repeat, be a sponge for an independent practice. Just keep absorbing. Even in law school, I will say, don't feel that, oh, I have to do corporate. I need not bother about moot courts. That's not it. You learn skill set. How do you application of mind? You learn how to work in a team. You learn if your fellow teammate is probably trying to trample you, you learn how to get over it. And with independent practice, those things are important. You should have, your mind should be like a search engine. Every information you're taking, somewhere it's stored, and then at the right time, okay, probably I read this somewhere. Probably if today you hear somebody arguing in court, you keep hearing, you don't know the facts, so it's not that you're understanding completely, but still keep on hearing. Probably 6 months down the line, you will have the same point. The client will come with the same issue, and you want to recall who was in that court that day, which lawyer was arguing. Let me just see if I know the junior counsel. Let me call up, ask if you have, what was the law point. And last, I think a skill, this can't be done in law school. Once you graduate, the skill of dictation. A lot of people do not agree. The newer generation may not agree. They feel that it's archaic, it's very old school. We can type it out ourselves. Personally, my senior, when I went, I'm so grateful to him. He absolutely made it a point. He said you have to draft, give dictation for letters. You can't draft, if you can't dictate writ petitions, SLPs, just dictate letters, just dictate proceedings, what happened in court. And I think it's a must. There's a reason why Supreme Court to District Court judges, everybody does it, because when you have a sea of documents and when you're typing it yourself, the flow is not the same as it is when you are dictating. When you are dictating, there is no, the flow, the thought process does not get stopped. You can just continuously talk about it.
Thank you, ma'am. So, ma'am, you talked about having a temperament when you are an independent practitioner, and even I think you are a one-man army when you enter into an independent practice. So, since a lot of people who wish to pursue litigation are first-generation lawyers and who belong to average economic backgrounds, what would be your advice to them, and how easy or difficult it is for them to make a successful career in litigation?
It is difficult, but if you work towards it, see, ultimately, the main thing is, first you need to understand, have the knowledge. Then you have to have the ability to guide the client through it. Now, there should be no crazy urgency to go independent, because you cannot learn law at the cost of client's interest. His interests are paramount. At least only after you have that developed that understanding that probably I know how to, the application solution, I know how to find out a solution, only then you should try and go independent. For independent counsels, most paramount is always be prepared with your case. Whatever brief is marked to you, be ready, because you never know when you get an opportunity, when the judge says that the senior, you ask for a passover and the judge says sorry, start arguing. Now of course the client has not paid for you, the client has paid for a senior, so you know you can't just start arguing. You say that I don't have the instructions, but the judge can say that, you know, I'm going to dismiss it. You start, the senior will come. At that point you have to be ready with your brief. You If you are not ready that day, the next opportunity to argue will probably come after 6 months, 1 year. And you grab opportunities. If your senior is in high court and there is something in district court, you say, I will go, I will do this, something small, I will do it. That is probably the first one. You have to become indispensable for your senior, just do so that he's relying so much on you. They know that, you know, if I give work, it will be done thoroughly. Yeah, probably that's the main thing I would suggest.
Anything, sir, you would like to add to this question?
I think ma'am has said most of the point. I would only say, and I think it's said a lot number of times by our teachers, by our parents, and throughout. Perseverance, hard work, attention to details, being focused. I don't see a reason why you won't why won't you succeed in any profession you choose. Believe me, honestly, I'm also a first generation lawyer. Nobody in my family is a lawyer. You know, I was in due for a year, and somehow I got into law school. And you know, I think it was all hard work. Of course, sometimes it may be 2 years later, 5 years later. It's all about a time. Even if you have no backing, even if you belong to, I don't know what this average economic background means, but let me tell you, if you are hardworking, good economic background, bad economic background, in the long course doesn't matter. There are enough people, if you are sincere, to give you that opportunity. Even in Delhi, there are seniors to whom if you approach, of course you have that level of sincerity. I have seen people whom I know personally. They are very simple background but very grounded, very hardworking. They have approached seniors, they are doing very well for themselves. Of course, people who have a good economical background have connections. It is, maybe it is easier for them if they want to exercise those. But if you are hardworking, and if you have learned, if you have read well, if you have not, whatever done with your time in college, I don't see why won't you succeed. You will. There's no question of not succeeding. Be hardworking. Have faith in yourself. Be honest. Be honest to yourself. Don't manipulate yourself. Don't be in any delusion, and you will do well. I don't see a reason why not.
I'll just add one more point to it, that you should have an impeccable reputation in court, because word travels very fast in corridors. You can lose your client, but don't lose your judge. It's not that you make up something just to win that case.
I think that is very important, and one should like keep this in mind. So this brings me to my next question about, like, in recent times we see a lot of partners and counsels from leading law firms starting their practice. However, few associates really make the shift. So do you think a shift from a law firm to independent practice should only be made at a later stage of one's career, or would you advise that the person start their practice early in life? Or basically my question is, what is the right time to make the shift from a law firm to an independent practice?
Okay. So I think it doesn't get reported. A lot of associates leaving, but what gets reported is when the partner leaves and joins independent legal practice. Therefore, your question may not be entirely correct, but I'm not getting into the validity of the question. The point is, and people, there is no, I don't think there's a hard and fast rule to that. But as ma'am pointed out in one of her earlier answers, uh, whenever you are comfortable, as she rightly said, that you know, when you will be dealing independently with a client, you will not be doing any injustice to them. When you think you are ready for that, please leave a law firm. If you really want to do a proper, you know, independent legal practice, obviously speaking, there's no such requirement, or there is no such mandatory requirement that if you're in a law firm in a litigation practice, you have to essentially go and do an independent practice. If you are happy, by happy I don't mean money wise only, I mean in terms of your career growth, in terms of you're getting to do good matters, you're getting good exposure, You're getting to brief seniors on a very regular basis. You're getting to get argue. There are a lot of solicitors, as in who don't want to argue. They are happy in briefing a senior, so they are content, and I don't see why they should want. But if you have that, we call it a kira of going and arguing in a court, then you must, and always, there's a saying that the earlier you start, the better mileage you get, of course. Like, so if your end goal, we were taught a concept called vector in physics, which means that when you apply force in the same direction, the accumulation of it will be more than when you apply force in two different directions. Similarly, if you want to do ultimately a court practice, the sooner you make. But as ma'am pointed out, you should know that I am ready for this. You can't just go half prepared, half baked. Then you will be a dangerous thing for yourself. You will damage yourself. So there is no hard and fast. There is no fixed time. I will do 5-year practice, then I'll go and do independent practice. No, it doesn't work like that. Some people can be ready in 3 years. Some people can be ready in 10 years. So that you will have to do an assessment of yourself.
I think the profession will absorb you at any age. This is independent practice is such that it will absorb you at any age. It's just your priorities. It really depends. Probably you want that. There's no denying the fact that when you start independent practice, there's obviously a cash crunch that happens initially. So probably maybe what you want is that to save a little and then go. In that case, you also develop you meet a lot of people, and then when you go independent, you can ask those law firms that I am going, please send me work. And if you from the beginning, if you think this is what you want to do, then you do it in the beginning. I think only issue is the more time that you take, it is probably the monetary thing that I feel that after a point it becomes more and more difficult. Like responsibilities increase, and then you become used to that certain monetary gain. Leaving it can be difficult, but again, that can also work to your advantage. You have built your base, so that can also work to your advantage.
All right. So there are two important issues, like which court one should practice at, and who should they choose as their senior. So what are the factors and considerations that come into play while making this decision?
Okay, I will address this.
Yeah.
Yeah. First thing, don't start from Supreme Court. You should not start from Supreme Court. You should start from high courts or the courts below. If you are not from Delhi, work it to your advantage. There's no reason that every person has to practice in Delhi or Bombay. If you're from any other city, work it to your advantage. Work in that high court. Suppose you want that probably one day I'll come to Delhi. Even then, I say, practice in your state's high court, build your base, because in Supreme Court, clients don't matter. What matters is lawyers from the high courts. Somebody, if you are in, say, Jabalpur, a Jabalpur client does not know that there's a lawyer sitting in Supreme Court. It is the lawyers, the clients will not know, it's the lawyers who know. And hence, if you have practiced in that court, the lawyers of that court recognize you, and probably after 3-4 years, if you move to Supreme Court, they'll send you to work. So that is one, the client part of it. Also, I feel you should not start from Supreme Court, because you do not get to structure your case from the very inception. A case is already built and then it comes to you. You're only working on the appeal. You're only working on the impugned order. But when a client just dumps certain files, certain papers on you and says that, I got this order from this government authority or this happened, what do I do? Then you have to choose which law to go to, or multiple laws, which forum. That is the real learning. And hence I said, don't start from high court or below that. Also, which seniors to choose? I think you should work with both senior counsels, designated senior counsels, and you should work with counsels who are doing a lot of drafting work. The two different sort of things that you will learn is in the office of a drafting counsel. Again, you learn how to structure a case from scratch. You see how they build up their case. You learn how filing is done, and in independent practice it is very important to understand the nuances. You need to go to the registry and say that, listen, why isn't my case getting listed, what are the defects. You need to go there with the clerk and do all that. So you learn all that in a drafting counsel's office. In a senior's office, what you learn is court craft. What you learn is that, as I said, that if there are 5 points and the court says that I just have 2 minutes, tell me one point. You learn from them what to choose and what not to choose, and then you meet the best of the briefing counsels in their chamber.
So, ma'am, you talked about that you kept a mental note of people who you should approach. So, how important do you think is maintaining connections when we talk about an independent practice as opposed to a law firm?
Very important. But I wouldn't call them connections. I would call them relations, because you have to maintain relations for life. It is not like a fishing thing that, oh, let me just go there, just get all the work from there. It's not like that. Suppose today you have worked, like I have also worked in a firm. Now, if I worked in that firm, after 10 years, a lot of counsels from that firm have gone independent. I have gone independent. Now, both of us complement each other. Both of us send each other work. Now, if I do not maintain relationship for life, that cannot happen. No matter, anyone anywhere can send you work, but it is not that you go with a targeted attitude. Let me join this organization and then I just grab all the brief from that organization. It does not happen that way. It's a 50-year for litigation. You think of 50 years. You don't think of 5 years, 10 years. But it's very important to maintain relations.
Because, sir, what do you think about maintaining connections?
I'm saying that it's equally applicable even when you're in a law firm. One cannot say that you need it more in independent practice. I would say that you need it with the similar sort of, you need, as ma'am said, relationships, of course, connections, relations, whatever word you may say, but the idea is to sort of broaden your exposure and horizon, not just in terms of taking advantage or whatever misuse. I'm not getting into the the value of it. I'm making a very value neutral statement in terms of that it's sort of, there is a saying which I usually talk, is that says that, and it's not just applicable in the profession, it's in personal life also. Rahman is sansar mein sabso milyo dhai, na jane ke hi roop mein narayan mil jaye. Now, of course, that has a philosophical and spiritual root, but you can take the principle and apply it even for the purposes of a client. Like ma'am said that she had a structural building aspect, she was able to contact an architect. Now, the architect was a Narayan for her in that particular case. So similarly, of course, the idea is not to take advantage, but the idea is to have more and more exposure, more and more relationships or connections, whatever terminology we may want to use, and to learn, because you learn. 2 people, 2 ideas, your 1 idea has become 2. So very important for firm also, undoubtedly.
So this brings me to a very interesting question. No preconceived notions, but is it true that independent practitioners have a better work-life balance than people working in a law firm?
Again, you should forget it for first 5 years. But after that, yes, you see, it's not that the profession is forgiving for an independent practitioner. It's equally unforgiving. But yes, I think you can take out time for your own things. Today, it may not matter for 5 years. It should not matter to you for 5 years, 10 years. It should not matter to you guys. But after that, if you feel you're getting burnt up, you can take out time for things that you like. And I think you should live a holistic life, and it does give you an opportunity to live a holistic life. But then again, it's not that the timings are sort of forgiving. Suppose if you had some family function, Friday, Saturday, you were busy, you have to work on a Sunday then. Somewhere you have to adjust. Maybe it's more adjusting. Only advantage, probably summer and winter vacation. As litigation counsels, all of us enjoy firm or independent counsels, and then we should cherish it. Nobody gets this. Only school children get it, and we should enjoy this fullest. But yes, you are your own boss. and it is sort of addictive. It's difficult. You just get again addicted to it. It's difficult to then get back to structured setup where you're pledging your time for someone else, when you just get used to pledging the time for just for yourself and for your interests.
I have a little different take on this, but while I agree with this is a popular thought process also, thinking also. So my point is that this cannot be the basis for you to decide whether you want to join a firm or whether you want to do an independent practice. So if you are thinking that if I join independent law practice and I will have a better work-life balance, then your fundamentals are itself flawed. Once you join a profession, and as I would say, we have mentioned a lot of, it's all about your priorities, how you have prioritized. What a lot of people in the law firm have a much greater work life balance than I have seen with an independent lawyer. I know independent lawyers, senior advocates who gives you meeting for 6 minutes, 7 minutes, and their work, their life is, of course they are their own masters, but their priorities when it becomes money, I don't see that they have their work life balance. So I don't think there is a straightforward answer to this again. And I know I'm giving answers which are little not straightforward, but my point is that you can have a work life balance even while being in a firm if you have managed your time properly, and of course after 5 years, not before 5 years, and in a structured setup. In fact, sometimes you have better sort of opportunities to do so because you have juniors. You can give them work, have a good time if you want. So both, I think, even in a law firm you can have a good work life balance. It's all about your priorities.
So, building upon what Vikash sir just said, do you think that an independent practice requires you to have a broader knowledge base or a more comprehensive skill set, considering that everything is done by the person himself or herself, as opposed to a law firm where the workload gets distributed among the entire team in a law firm?
Yes, you do need everything, all the skill set, but I am in favor that probably after a time you should start delegating work. For example, if suppose I have to dictate a petition, I would want to dictate the broader things and then ask a junior colleague to fill in the gaps. Something like, say, a formatting, skills like that. I think I would ask the clerk to do it. So yes, initially you need to have all the skill set, but moving on, I think even independent practitioners need to give away that work.
Yeah, I think I agree. I think even while you're in a law firm, you're in a proper litigation team, not just doing advisory work. And if you have your own sort of understanding, and depending on what kind of a senior you are working with, like I was very fortunate to work with Mr. Sharad Matkar. He was a partner at Bombay office. Even when I didn't have a matter in court, I was working in London Chambers, which is just very close to Bombay Stock Exchange. High Court was just across the road, and City Civil Court was just across the road. He will just tell me, just because go, don't worry about matters, just go to the court and sit there. Now I'm sure a lot of people won't be this lucky. I was lucky to have such a senior. I got to learn a lot, as ma'am rightly said, just by sitting in the court and seeing how the various advocates are arguing, how the judge is posing questions. You learn. The most learning happens in a court, and especially in a trial court and high court, which has original jurisdiction. Of course, learning is everywhere. But for a new big, like for a beginner, go to court. Even if you don't have matters, sit in a court. Sit. And as far as the question is comprehensive, I think if you don't need it, but if you have it, then no one can make you a fool. So no one can take you for a ride if you are aware as to how a filing is done, how objections are removed. You should be aware whether you will need it being in a firm, because a lot of work are done by your clerk or your juniors. But if you are not aware, then they will take you for a ride. So it's not a necessity, but in my view, it is important to have that all set of. You should be aware in its entirety. When you make a vegetable, you should be aware from the frying stage till you make a gravy. You can't be just putting spices and condiments and salt. Doesn't work like that. You should be aware of the entire cooking process from beginning to the end, and serving also. Yeah.
Indeed. So, to conclude this session, for those students who know that they wish to pursue litigation but are unsure as to whether they should go for independent practice or opt for a law firm setup, what would be your advice? How to get to that decision?
Do you want to say, Vikas? Do you want to go first?
Okay, see, so I think the answer is in a lot of conversations we just have. Speak, make relations, connections, speak with your seniors. When you're interning, analyze your temperament, see that which area you are more comfortable with, which area increases your efficiency. In terms of, a lot of people may not be very good at speaking, but they may be brilliant in writing. There may be some people who are good at both. You have to do a very neutral, unbiased sort of an analysis of yourself, and make a holistic sort of approach. But in that, again, don't manipulate yourself. A lot of people are in a lot of delusion and manipulations. Then they manipulate their own self. When you mark yourself higher than what you actually are, you will end up making stupid decisions. So what you can do to check it, that you speak with people who you think are in a position to give you good advice, in terms of who have also sort of been in that position. And like this conversation what we are having, have this sort of conversation more. Speak with people, speak with your professors, not just professors, also speak with advocates around, and just get an analysis of how things are. And but before you speak with others, do a introspection and your own analysis as to what gives you more pleasure, and not just pleasure in terms of like what you are efficient and good at. And then take a call. And believe me, there is nothing like, it's not a case that when you join a law firm tomorrow, if you want to go in independent practice, as ma'am said, it's not that you can't do that. You can do that. Or you go to an independent practice, and if you want to join a firm, it's not that it won't happen. It can happen. You want to join a corporate house, you want to join a bank, whatever. So you don't have to choose something very rigidly that, no, I'm going to do this and stop. No. When I was in college, I was thinking I will do UPSC. Being a Bihari, that was, there. But at the end of the 5 year, it was like, nahi, UPSC nahi karna. So whatever, like. In fact, my thinking was I will work in a law firm for 2 years, we'll earn some money, and then we'll give UPSC. But at the end of 2 years, it didn't work. So do analysis. Self-analysis is very important. You will reach to a good decision.
Your question as to whether law students should choose a law firm or independent practice, I think that decision should be done. As I said, that there's certain temperament you need for independent practice. It's really what suits you, what your priority is. Who are we to suggest what works for whom? If there is a certain, if I can tell you what the challenges are and why it is still worth it in independent practice. If you think you fit in that, well, you must do it. And if you think that this is not what you want to do, because see, financial insecurity in the initial phase is obviously there. If you think that after 5 years of law school, this is not what I want to go through, you absolutely have the right to that decision. You feel that, no, I do not want to be in a setup where in a position where probably I may need support from my parents. Again, that's absolutely your right to think that way. I'll tell you certain challenges of litigation, and still I feel why it is worth it. The challenges, of course, it requires patience. You need to have a broader horizon of, say, 50 years. You cannot think just that next 5 years where I'm gonna be. It requires that temperament because it's physically challenging. But why I feel it's worth it, Vikas rightly put it, it's that kida. When you argue, it's a sheer joy. It's a sheer joy to argue in court. It's a sheer sense of satisfaction when there is some favorable order, sometimes not even favorable. If you just had the opportunity to talk, probably you're just very happy. You stood on your legs and it gives you a kick. Just that, if you have observed in your law school that I had this, probably I did some moot court or something, I had this, independent practice is your thing. Also, if it gives you a sense of ownership on the client, the responsibility is more. So you cannot have that careless, reckless attitude. There is no senior seeing your work, overseeing your work. So if you think you are ready for that sort of responsibility, it's for you. Or else, as I said, any choice you make, it's really okay. We are lucky. If it was 20 years back, everybody who did law had to go to a court. We are lucky that that's not the case today. We have so many verticals we can do, and then why not take benefit of all of them?
Thank you so much, ma'am. So do you have anything to add?
Yeah. Just to add to what ma'am said, I think you have a not that I'm promoting firm, but I'm saying even when you want to join a firm, you will get the same level of satisfaction if you are made for that
Yes.
what a
Yes.
firm requires. Within this 9-10 years, I have got so much of exposure. I did the BCCI matter in Supreme Court. I'm doing ILMFS matter. I got to interact with former ASG. We know that. What I'm trying to say, I don't want to get you names. What I'm trying to say that if I was in the independent practice, maybe I may not have been in a position to interact with the kind of people or senior advocates I have interacted by being in a firm. So it's all about temperament, most importantly, and understanding as to what you are good at. And so I think even the independent practice as well as a firm practice or any other legal career opportunity will provide you the level of satisfaction if you are meant for it. If you are able to understand, analyze, and assimilate it, you will do. No, not every lawyer can argue. Not every lawyer is only made for drafting. Not every lawyer is only. And as ma'am rightly said, 20 years back, there are a lot of options were not even there. Now there's so many options. You can go to JAG. You can go to banks. There are also a lot of banks and big corporate houses. They have their own independent legal teams who do 90% of their work because they don't want to pay outside lawyers a lot of money. They are on their rolls. So there's so many opportunities. You have to sort of do that introspection, and there are a lot of career opportunities. And firm practice also will give you the same level of satisfaction as an independent practice will give.
Thank you,
Thank you.
sir. Thank you, ma'am. I guess it was a wonderful discussion, and it personally cleared a lot of doubts that I had. And people like me sitting in this webinar, I also made my notes just for my reference. So the floor is now open for questions from the audience. You can unmute yourself and ask any questions if you have from our panel.
I think we spoke so nicely that nobody has any question.
I personally have one question. So, considering we are in this pandemic right now and everybody is opting for online internships, so is there any suggestion that you would like to give us regarding how we should interact in an online platform, and or what should be our attitude, or how should we present ourselves in an online platform when we are interning through an online mode?
I would say that you have the same level of sincerity. Have a routine. Just because you are at home, don't it doesn't mean that you work whenever you feel like. Work. Consider as if you are in office. Have a sort of small space in your home, house, hostel, wherever when you're interning. Consider that if you were going to the office, what hours you would have been dedicating and what you will be doing. A lot of time, what is happening today that people are at home, they are doing their work and they're working also. So what I'm saying that you can have certain liberties, of course, if it is necessary, but make a routine. Take the job or whatever internship you got seriously. Give your best. Be polite. Be focused. Have attention to details. And if you at any point, this is I've seen a lot. If you don't have work, don't sit idle. Ask for it. Go ahead and ask for it. Sometimes the senior or the concerned associate or partner you're working with, they will say, "Acha, abhi nahi hai, we don't have work. We will give you some time." Say, "Okay, sure." Follow up with them. Email them, message them. See that what they're more comfortable. A lot of seniors are not comfortable with you sending an email to them because it's something which is very formal. Message them. As ma'am said, make a connection, make a relation with that senior also. Maybe possibly if they're happy with your work, they will help you in getting a job in whatever, either in a firm or an independent practice or whatever. So be sincere about it, be polite, be focused, and be more forthcoming in terms of ask for work. Just don't enjoy the internship I've got. I'll get a certificate at the end of the 30 days or 28 days or whatever. And I don't need to do. No, no. You are harming yourself in the long run. While temporarily it may seem that, oh, such a nice internship, had to do nothing. Very, very dangerous.
So your visibility has got affected. What visibility you would have got in physical presence, that has got affected. And as I said, it's the connection for life that you lost that. So make up with work, good work, quality work. There no loopholes, and be forthcoming. I think what Vikas has said is probably covered it all.
Good evening, sir. I had one question. Am I audible?
Yes, please go ahead.
So I'm 50th year student Gokul Holani. Sir, I wanted to ask a question as to like a lot of times you have seen our seniors or even we have looked at people working in law firms for like 2 or 3 years or like more years and then they're like quitting to go independent, sir. So is that advisable or like if you're like entering the law firm sector, should we like generally stick to it and then, or if we want to actually go independent, we should start it like from start only and not like spend our time few years in law firm and then go independent?
I will first say that you should treat your law school as a laboratory, your internships as a laboratory. Do everything. This is the time to try everything. You go with an independent practitioner, you work in High Court, Supreme Court, Delhi, Bombay. I have done a corporate internship also. Do that also. I have done IPR internship. Try everything so that at least you have some basic understanding that do I have the temperament or the liking for this work. Probably even if you feel at that time that I do, and then maybe 2 years later you feel that no, I don't, but at least you are in a better position than if you did not try anything at all. So utilize this time completely. And if you feel that you go work with an independent counsel, if you feel that you do want to go for independent practice, join 2 3 independent counsel, join a government counsel, join somebody an AOR, join a senior counsel, work with all of them, and then see what do you really feel. Is it because it's not same just as the moot courts. There's a lot of physical strain also involved in it. If you think if it works for you, then why not? But shifting that, you say, I don't think there is any rule as such, or any difficulty, any handicap that after 2 years you cannot make the shift. Either ways, that's not the case. But if you have more knowledge from the beginning, why not? Because I think he's frozen.
Yeah,
Did I answer your question, or is it
Yes,
anything
I
else?
mean that like addresses that. Thank you, ma'am.
Thank you.
yeah, I think
Do
I
we
agree. Nothing to add to this.
because your voice is a little muffled, can you maybe switch off your video, and then we might just have some clarity.
Am I audible?
Yeah, you're audible now.
Yeah, I was saying that I think we have discussed this point, and as you rightly pointed out, I think don't go with any rigid mind frame, and see, analyze it after being in a profession or whatever, being in a firm or an independent practice, 2 3 4 years is the minimum timeline you should like give yourself, and then take a further course of action.
And if you think that for 2 years, 3 years, I did one, and then I had to make a switch, it all got wasted. It did not. The knowledge did not get wasted. The skill did not get wasted. The connections you made did not get wasted. Everything adds up.
Right, ma'am. Thank you so much. And because what we feel is like, because since in law firms, the type of work that comes in, it's pretty much different from what an independent counsel actually does. So like, because their work also substantially requires groundwork and everything. Whereas in law firms, we are not acquainted with that. So that was one of my concerns.
Also, what independent practitioners, they have to do every sort of work, because when you start your own practice, you can't say no to any work. You have to take up anything. You have to, there are practical issues. You have to run your office as well.
Right, ma'am.
Hi, this is Raj. I'm from the third year. I had a question specifically related to independent practice. So, prior internships, which have been at trial and high courts, and through communication with seniors, I just find that a lot of times a courtroom intensive practice gets very frustrating because there are adjournments. You wait the entire day just to have a judge not show up or something like that. How do you deal with that frustration? And is it just feels time sometimes gets lost that this could be spent preparing something else, and it just feels that talent is getting wasted sometimes. How is that dealt with in an independent practice? Because whereas in firm, there's always going to be something to do.
I think that's part of litigation. I won't say it's just a part of independent practice. That is part of litigation. We have to deal with two, three things. We have to deal with, there are times, dates are given, adjournments, because that is given by courts. That's nothing to do with the courts. Do not see that, oh, it's a firm, so I'll not give an adjournment, and if it's independent lawyer, I'm going to give that. That's not the case. Both of them get it. That's a part of the game. You have to accept it. Also, another thing you have to accept is that, suppose you are at item number 31, or just say item number 5, and you think that, oh, today I'll be free by 11 o'clock, and then you have a Passover, and then you're just sitting in court doing nothing. Again, it's a part and parcel of it. There's nothing you can do it. Utilize that time. You go to the library, you read up your cases. You can always have draft in your, suppose you have a seniors chamber in, say, high court, and then you think that the matter is not reaching for some time, then probably you can just watch. The boards are online now. You watch the boards online, you sit in your office, and then you start drafting something. You have to make the best of it, but that is something, there is no escape. And there is no escape more in district courts. More the more the dates, adjournments are there. But I wouldn't say that it's not the case in high court or Supreme Court. Both the places, there that issue is there. So bottom line, just make best of it. Make the best of it. If nothing, just speak to some good senior is there. Just speak to him, sir. I heard you argue in this case. So what was it? Tell me about it. Just learn from them. Or if nothing, then just do courtroom corridor gossip. If nothing, which is also important to you understand. Say a certain judge, you understand how is he dealing with the cases. That's also part of it. You need to understand all those things. And you do that only when you are there in the courtroom, you are meeting other lawyers. That is how you do it.
Thank you. That answers my question to a great extent. Also, I didn't mean that passwords aren't given to only independent counsel, not firms. I just meant that in a firm, rather be sitting in an office and doing work, whereas an independent practice would, I believe, be more courtroom intensive.
No, but if your senior has a chamber, if not, if there's always a library in the court, why can't you just carry your some drafting that you have? Why can't you just carry it to the court and do it there? I think there's more. Okay, let it be. I just say, just make the best of it. It's not that you cannot.
Understood. Thanks, ma'am. Thanks. Hopefully, yeah, as more and more time passes, we realize how to navigate these things. So possibly with that. Thank you.
Do we have any other question? I guess the session was so extensive that we don't really have any questions. So thank you so much, ma'am. Thank you so much, sir. It was a wonderful session and I personally learned a lot. So thank you so much.
Thank you so much.
Thank you.
So I think we can now end the session. But before we go, I would like to thank Rachita ma'am and Vikasa for taking out time out of their schedules even before this session, because the speakers actually helped us plan the session to a great extent. So I would.
Can we pause? Like, I have one quick question from Vikasa.
Yeah, please go ahead. Please go ahead.
Yeah.
Yeah.
So, sir, I had one question as to like what to be like as a principal associate you're expecting from A0s coming to the litigation side of the practice of the firms.
See, the expectation is very simple. You should be sincere, hardworking, and you cannot miss on facts. Nobody is expecting a ready-made solution from an A0 or an A1. What is being expected from you that you have read the papers, the facts properly, and you have done some research, you have applied for yourself. That's it. That is all what is required from a A0 or a first year associate or a second year associate. Nobody is expecting a solution from you. But what is being expected from you is your sincerity, the level of sincerity and focus and attention to details which you show to your senior. That's it.
Right, sir. Thank you, sir.
Thank you. Okay. So I have placed my time to the firm, so I have to attend a meeting.
Yeah, we were told that sir has to go. But yeah, I just quickly wanted to take this opportunity to thank everybody who came and everybody who attended the event and the team at Alumni Fest for putting in all the work. In case you have any queries, doubts, suggestions, or just some good old feedback, please feel free to write an email to us. And in case you want to reach to the speakers, please feel free to let us know about that as well. We'll make sure that we connect you with the speakers. So yeah, with that, please come for our future events as well. I hope you had a good time and thank you so much. Have a nice day.
Thank you so much.
Thank you, ma'am.
Thank you.
Thanks.
Thank you.
Bye.